Let me see.
Get off mute.
Okay, so let's go on the record on cause number DC 206180, equipmentshare.com Inc. versus Montemayor Development LLC. Council and parties make your appearances.
Good morning, Your Honor. Leon Gill with Chief and Stone on behalf of plaintiff equipmentshare.com Inc. 2409-4204. We're calling an audible, sir. So Richard Wallace wasn't available today, so I'll be subbing in for him.
Okay, and Mr. Montemayor, do you want to introduce yourself?
Yes, sir. Mike Montemayor with Montemayor Development. Can you hear me okay?
Yep, we can hear you fine. Mr. Gill, you may proceed.
Yes, Your Honor. So in October 2020, our client served post-judgment discovery on defendants. Then we were in a spot where we had to file a motion to compel responses to that discovery because we had not received anything back from, at that point, defendant's counsel. Since that time, their counsel has withdrawn. That order was granted on or about January 25th, 2021. And to date, now here in July 2021, we still have not received any responses to either the interrogatories or the request for production that were sent in October. So we're requesting an order to compel the responses, and we're also requesting sanctions in the amount of $1,000 as described in Mr. Wallace's affidavit for our fees and effort.
Mr. Montemayor, why didn't you answer those requests?
Well, I don't have a good answer for that, sir. I saw one letter and I should have responded, but I just did not. I apologize.
Mr. Montemayor, just let me talk to you about kind of where we are in the process and kind of what may happen in the future, because I see this all the time. Is so they've filed a request, a motion to compel. You have not complied with the requirements under the rules of civil procedure, and so I'm going to issue what's called an order to compel. So this is kind of the first step in a multi-step process that could, hopefully not, but could lead to you being incarcerated, hopefully not. And so the first step is this motion to compel. I'm going to order you to respond to these because you're required to. If you respond, I'd encourage you to get an attorney, but if you decide not to, you can respond on your own. That would be a very good thing. If you fail to respond, let's say you say, you know what, I just don't have time. I don't want to do this. What's the big deal? Then the next step would be he could request what's called a show cause, because you would have violated a court order. And what a show cause is that they are going to request that you show up at the courthouse. If you don't show up voluntarily, they would send a constable to go get you, and they would bring you in, and then we would order you again to respond to this. And at that point, if you fail to respond, then the two options are we could do a $500 fine, or we could put you in jail for up to 6 months. I don't like doing that. That's never my first choice. What we wanted you to do is comply with the rules, just like everyone else does. We're a nation of laws and rules, and everybody has to obey the same laws and rules. You do, just like everyone else. And so, so you'll need to make sure that you respond to these questions just like anybody else. And there is a judgment against you. Is that correct, Mr. Gill?
Yes, Your Honor, that's correct.
And so this is part of the problem with having an outstanding judgment, is that they're going to be able to kind of do this. These things can last up to 20 years. So you're looking at the possibility of having to go through depositions, go through multiple requests for disclosures and requests for discovery, and you have to respond to those, and I told you kind of what the consequence is. Do you have any questions, Mr. Montemayor?
No, sir.
So what I'm going to do is I'm going to order this motion to compel to be granted. Do you still have a copy of those requests?
Previous one, the one where they requested.
Mr. Montemario, do you
Yes,
still have a copy?
I'm talking to my wife. Do we still have that copy? Can we request another copy, please?
Can you email him a copy of that, Mr. Gill?
Yes, I sure can.
Thank
And
you.
what I'm going to do is also award it $1,000 in sanctions. But if you are able to answer these, unless you answer these fully within 2 weeks, if you answer them fully within 2 weeks, you're not going to have to pay the $1,000. So I'm going to give you kind of another chance.
Oh,
If
good. Thank you.
if you don't answer them, then you have to pay the $1,000, and then you could be subject to a show cause and being picked up by a constable and potentially in the future, possibly incarceration. So we hope that doesn't happen. We want you to comply. And there may be things in there that you don't want to answer, but unfortunately, because you didn't answer these within 30 days, you've waived any objections. So you have to provide them everything they've requested. Does that
Okay.
make sense?
Yes, Your Honor.
Okay. Okay, great. Thank you, Mr. Montemayor. Anything else, Mr. Leon?
That will do. We appreciate your honor.
All right, I've signed an order. It should be scanned later today, okay?
Thank you,
Excellent.
Your
Much
Honor.
appreciated. Have a good
Thank you,
weekend.
guys. And make sure you send Mr. Montemayor the discovery and also send him a copy. Do you have his email address?
Yes, your honor, we do.
Make sure you send him a copy of the order as well.
Very good. We'll do today.
Thank you, guys.
Thank
You
you.
have a good day,
Thank you,
okay?
Leon.
Thank you.
Thank you, Leon. Okay. Thank you. You
Mr.
too.
Lopez, what are you here for? You're muted, sir.
Your Honor,
Lopez.
I'm here on the Luminant motion for leave to designate responsible third party, Eric Hambrick matter.
Okay, yeah, that's set for 10. Is the, you're opposing, are you with Mr. Queenan's office or Mr. Dyer's office?
I'm with Kevin Queen's office.
Okay. All right, I don't see anyone here with Mr. Dyer's office, but it's not 10 o'clock yet. So we're gonna wait for a few minutes, and once he gets here, we'll go ahead and start the hearing, okay?
Sounds good, Your Honor. Thank you.
I'm gonna take a quick break. I need to sign some orders, and I'll be back on as soon as we get the hearing started.
Sounds good.
Mr. Britt?
Yes, Your Honor. Good morning.
Good morning, guys. Are you here for the Hambrick case?
Yes, Your Honor. Here for Mr. Dyer.
Sounds good. Let me go ahead and put, you guys want this on the record?
Yes.
All right. Tony, you there?
Yes, Judge.
All right, let's go on the record on cause number DC 206180, equipmentshare.com versus Montemayor Development. Counsel, make your appearances.
Other case, Judge.
This
I'm
is
sorry, what'd you say, Tony?
I think we're on the second case.
I'm sorry, you're right. Let's go on the record on cause number DC 207704, Eric Hambrick versus Luminant Mining Company. Counsel, make your appearances.
Carlos Lopez, and I have the pleasure of representing Mr. Eric Hambrick.
Ben Britt here for Defendant Luminant.
All right, guys, let's get started.
May it please the court. Judge, what we're here for today is a motion for leave to designate the plaintiff's employer, Warfab Industries, as a responsible third party. This case is involving an on-the-job injury that happened back in October 4th of 2019 at a strip mine in Cossie, Texas. The workers were repairing a drag line that's used to take material out of the ground, and they were fixing a cable for this particular drag line. And in the process, there was the cable was getting lifted up by a crane in order to put the cable back onto the drag line so it could get back in use. And the cable came loose from the crane and came down and struck the plaintiff, I believe, in his ankle. And so Mr. Hambrick filed a workers' compensation claim against Warfab, which is why they're not a party to this case, since they are exempt from being sued directly. So what we've done here, Your Honor, is file this leave motion alleging that Warfab was negligent in several ways. You know, the typical, negligent in training Mr. Hambrick, negligent in providing a safe place to work, negligent in implementing proper safety procedures, kind of the typical things that one would see in an on-the-job injury. And what it appears, Your Honor, is that the plaintiffs have filed an objection that just simply makes the conclusory statement that there's not sufficient facts pled. There's no explanation or inquiry as to, or letting me know what other information that they might need. I mean, we've specifically pled, Your Honor, 7 different distinct ways that Warfab was negligent. So I don't know, how much more specific we need to be to give them fair notice. I mean, Rule 47, which many courts have said applies also to filing these types of motions, discusses that a petition is sufficient in a cause of action or defense may be reasonably inferred from what is specifically stated in that pleading, even if an element of the cause of action is not specifically alleged. Here, Your Honor, maybe we didn't plead every element of negligence, but we've certainly given them adequate notice of how we believe Warfab was negligent in these 7 different ways, which gives them notice that if they need to get an OSHA type expert to say, no, Warfab wasn't negligent in all those ways, they've got, proper notice to do that. The last thing, Your Honor, is, the plaintiffs have the remedy, according to 3304, of filing a motion to strike. If they believe, after adequate discovery, there's not sufficient evidence to establish that Warfab was negligent in causing this incident, they can file that motion to strike motion and take it up with the court, and whether or not that Warfab can be added or on the charge, whether or not, on the liability question. So we believe, Your Honor, that this motion provides ample information and facts to give fair notice to the other side as to what we're alleging Warfab did in contributing to this accident and to Mr. Hambrick's injuries.
Okay, response?
Yes, Your Honor. Carlos Lopez here. Appreciate the time. I don't want to go over all the facts and where I disagree, but generally he did kind of explain how the incident happened. And generally I don't have problems with how motions for leave are pled or the facts that are provided in them. The issue that we have here, however, is that Lumina itself has been sued as the owner and operator of the Coastal Strip mine at issue. In this motion for leave, Lumina is saying, no, it's Warfab that is the owner and operator of the Coastal Strip mine. And this motion for leave was filed back in April. And subsequent to that, we served request for production and requested directly from Lumina, how is it, give me the documents to support any of this, that they're the owner and or operator. And in fact, that was a topic of a conversation that I had with counsel earlier this week. Where are these documents? You're saying they're the owner and operator, and there's nothing that's been produced. So while I don't have a problem always generally with the facts, here the facts that were given in this motion for leave are inconsistent with the reality, at least from the evidentiary standpoint. And while I know that the plaintiff still has a remedy to wait to a later point to strike, I also have the ability to object based on the facts here, because they can make these allegations, but they're not actual facts. So if they're going to be standing on the point of Warfab as the owner and operator, we need some more facts supporting that, because I need to know exactly what the kind of discovery I need to be doing on my end, other than what I've already done, to be able to determine if that's even the case. So on that basis, Your Honor, is why we're asking for the defendant to replead their motion for leave to provide some additional information, because if they're going to take that position, I need to know specifically how they choose to support that, because through the discovery I've already done, there's nothing that's been produced.
Response?
Yes, Your Honor. First, there is no dispute that Mr. Hambrick was working in the course and scope of his employment with Warfab when this incident occurred, period. Secondly, several courts have ruled, Your Honor, that in determining whether to grant a motion for leave to designate a responsible third party, the trial court is restricted to evaluating the sufficiency of the facts pleaded by the movement and is not permitted to review the truth of the allegations or consider the strength of the evidence. So even if we dispute about the facts, the court is only to consider, is there enough facts alleged to give the other side proper notice? And Your Honor, and I'll go ahead and we aren't going to make the assertion that the plaintiff's employer owned and operated this mine. That's not going to be pled in this case. But regardless of that fact, whether or not that's true or not, Your Honor, we have pled 7 different distinct ways that Warfab was negligent in contributing to this incident and to the plaintiff's injuries, which sufficiently meets the requirement under Rule 47, as we've discussed earlier.
Your Honor, if I may just have a brief response, 2 sentences.
Okay.
And the reason why is because of what counsel just said. Page 1 in the background of his motion, and on page 2, before he goes into the negligent actions, Luminant provides, Warfab is the owner and operator of the Coastal Strip mine and owned, operated, and controlled the Coastal Strip mine and equipment. So what counsel just said is inconsistent with the motion, which is where I take issue.
That's again, Your Honor, a dispute of the facts, which we just discussed, Your Honor, aren't even supposed to be considered. It's about a sufficiency of the facts that are alleged.
But I thought you just said that you were not going to make that allegation, but apparently you did make that allegation.
I didn't prepare this motion. I've just now started taking over the handling of this case, Your Honor. But whether that facts, again, it doesn't matter in the court's determination of whether or not the motion should be granted. Whether the facts are true or not isn't even to be considered. It's whether or not the facts alleged are sufficient to give the other side notice, and whether or not. I
don't disagree with you. You just said that you weren't going to make this allegation, and that's my only point is that do you want to non-suit that particular allegation, or I'm kind of confused too.
I'm certainly agreeable to dropping that line from the motion and that specific allegation is no longer being pled.
So you're
But what we
non-suiting.
are-
I don't know if non-suit is the right word, but anyway, you'll need to just,
Replete, I would suggest.
do you want to replay? I don't know. This is kind of unusual because I generally agree with the defendant is that this is a very low standard. You know,
And
a lot of these,
I'm sorry.
go ahead.
I was going to say repleting, I think, satisfies the issue or addresses the issue. And because it is a fair notice pleading, I generally agree as well with respects to how the facts are kind of laid out. But fair notice is providing fair notice so that I know plaintiff what kind of discovery I need to be doing. You know, and if we need to do discovery as to owner and operator is one thing, but if I don't, that's another thing. So that's why I think we just need to address that. And I think repleting, at least from my understanding of how these matters are resolved, he takes that out of these allegations, I think we'll be good.
Will you agree to replete this?
If counsel will agree that he won't be filing an objection, yes, Your Honor, because otherwise we're wasting the court's time and everyone else's on such a low threshold to be disputing over a simple one fact that's not even supposed to be considered by the court one way or the other. I mean, that's, but if he'll agree to not object, I'll certainly replete.
All right, the court will grant the motion. You've agreed to replete that one fact, and I did not see an order submitted, and maybe I missed it. Do you know when you submitted the order?
It looked like I looked at that yesterday, Your Honor, and I couldn't see that we did either. So I will, I'll get you one.
So let me give you this instruction. Go ahead and e-file that order, email my court coordinator, and on the order say that on July 23rd, 2021. So instead of at the beginning where it says on this day, but on July 23rd, 2021, the court made the following ruling, or however you want to put it, but make sure you include that at the very beginning so I can tie it back to this date. It makes it a lot easier. So any other questions, guys?
That's it, Your Honor.
Thank you, guys. You guys be safe, okay?
Thank you too, Your Honor. Have a good weekend.
If just to clarify, I would assume that what you're granting is what will be the repleted motion for leave. Is that what we're doing?
I don't think I have the option. I just have to grant his motion and then he's agreed to replete. I think that's I don't have the ability to I mean, he's right. I can't just say that there's a repleted motion. He's orally said, represented on the record that they're not making that allegation. He's represented on the record. If he doesn't do it, then you need to take appropriate action. But, you know, he's stated this all on the record. So there's legal consequences to that, obviously. So thank you, guys. You guys be safe.
Thank you, Your Honor.
Thank you, Your Honor.